Hello, this is Attorney James Ratchford. I'm here to talk to you about the sequential evaluation process. This is a pretty boring topic, but it might be useful information to know. In this step, we're going to talk about Step 1, the substantial gainful activity threshold. And this is important to know about if you are working part-time or even working full-time while pursuing a claim for Social Security disability benefits, because this is a very important step that could impact the viability of your claim. So the question at Step 1 is, technically, is the person performing substantial gainful activity? And there's a specific legal definition to substantial gainful activity. Substantial gainful activity, well, we could break it down, is work that is both substantial and gainful. And substantial basically means work that is significant in quantity, work that is either full-time or above a certain dollar threshold, while gainful means that you have to be turning a profit from it. Gainful activity excludes volunteer work or housekeeping in your own home, your own chores. Things that you are doing that are not for money are generally not considered SGA. But substantial is a pretty important threshold, and it can be met one of two ways. It's either going to be met by a full-time equivalent work, so if you're working 40 hours a week, or if you're earning the dollar threshold, which in the year 2020, the dollar threshold for SGA is $1,225. That means that if you're earning exactly that dollar amount or more, then you are performing SGA and you are not qualified for Social Security disability benefits. If you are earning less than that, even $1 less than that, then you can qualify for Social Security disability benefits as long as your work is not full-time. Because if your work is full-time, 40 hours a week, then that's going to constitute SGA even if the dollar threshold is not met. Now generally, when we get to it in a hearing, we're talking about the dollar threshold, but a person can work full-time at minimum wage and make under that dollar threshold and still disqualify. So it's important that if you're working while pursuing a claim for Social Security disability benefits, make sure that your work is only part-time and does not rise above $1,225 a month. Now that's not to say that you shouldn't work more than $1,225 a month, because frankly, if you're capable of working and earning that much, you're probably better off working than collecting disability benefits. Most people's Social Security disability benefit is going to be $1,500 a month or less. So the odds are, if you're able to earn $1,200, you're probably able to earn a little more, and you're probably able to earn more than your Social Security disability benefit amount, or about the same while not having to work full-time. And there are non-economic benefits to work, such as it's good for your mental health and it's good for your social life. So it's not always correct for somebody to reduce their work just to qualify for benefits, when qualifying for benefits may not actually be the best thing for them. Now, in today's day and age, we're dealing with a COVID-19 pandemic outbreak. And that pandemic has significantly impacted the workforce, and we are going to see more part-time workers who are not able to get enough work to meet the threshold of SGA and disqualify themselves for disability. So it may come up more in the near future that we're going to see part-time workers who are more concerned about this dollar threshold. It is important to note that the judge will not only determine whether you exceed the threshold, but whether you could exceed the threshold. Now, this is not technically the way that the analysis is conducted. Technically, on paper, the analysis is strictly conducted on the basis of your earnings. If you are earning less than $1,225 a month, you are not performing SGA. Here's the caveat. If you are working and you are earning close to that amount, but not exceeding that amount, and it comes across to the judge that you're intentionally limiting your work for the purpose of staying below that amount, then the judge may look more critically when evaluating your functional capacity assessment and determining whether you're able to do other work. The fact that you are coming very close to that threshold may give a judge greater skepticism in evaluating your claim, and may make it more likely that the judge will find that you are capable of working full-time, even if you are not fully working full-time at the moment. So it is important, when looking at this threshold, to be careful not to just strictly play by the rules and technically satisfy the standard. If you're clearly gaming the system, a judge is going to catch on to that and it's not going to go your way. So if you're able to work, you really are better off working. I'm not going to ever encourage anybody to intentionally stay off work to get Social Security benefits, but you do want to be mindful of that dollar threshold when you do so. We do evaluate it on a quarterly basis. So when you get to a hearing, they're going to have an earnings record, and it's going to break down your earnings as reported to the IRS quarter by quarter. And so what's going to happen is we're going to have an earnings record that says in the first quarter you earned $4,000. Well, $4,000 in a quarter has to be divided by 3 months because the threshold is assessed on a monthly basis. So they will take that quarterly assessment and divide it by 3 in order to get that monthly amount. So if it's $4,000, they're going to divide by 3. That's $1,300 and change. That's above the threshold. So that person's going to be disqualified at step 1. Sometimes it's helpful to get additional documentation to prove that a person was not over the SGA threshold for the entire period, or if they were just below it, that they stayed below it for the entire period. So sometimes it's necessary to bring in your pay stubs or other documentation of your income to prove on a month-by-month basis what you actually earned in order to demonstrate that you were below that threshold. So if you have any doubts as to whether you're below the SGA threshold or if you're right on the borderline, this is the topic that's very important to be upfront with your attorney about. I can't tell you how many times I, as an attorney, have been blindsided by SGA findings when I evaluate an exhibit file before a hearing or even during a hearing, as the judge often has a more up-to-date exhibit file than I do. And it has happened a couple of times that I've seen very recent earnings that I was previously unaware of that my client hadn't told me about that suddenly pose a step 1 issue. So if you are working, it's important to let your attorney know so that we can appropriately deal with this issue in preparation for the hearing. So that's step 1. Tune in for more videos on the other 5 steps. Now, I don't expect this to be exciting or scintillating, but I hope that this is useful information for you. And if this is helpful, consider using my law practice to help you in your claim. Thank you.